Mr. Singler.
Good morning, my lords, my lady. I appear on behalf of the appellant in this matter with Mr. Al-Karim. Mr. Gorgie, King's Counsel, and Mr. Jenkins, King's Counsel, appear on behalf of the respondents. As you will have seen, this appeal arises out of the respondents' decision in 2015 to terminate a distribution agreement in respect of their beer products in the Bahamas. That agreement was originally entered into in 1975, so by the time the respondents decided to terminate, the parties had had a 40-year relationship. When they did terminate, the respondents accepted that they were under an implied obligation to give reasonable notice, but they only gave 3.5 months' notice. Now, the learned judge held that 3.5 months' notice was inadequate. She concluded that a reasonable notice period was 15 months. That was a conclusion which she reached following a trial at which she heard evidence from factual witnesses on both sides, plus an expert witness on behalf of the appellant. And as you will have seen, she produced a lengthy and detailed judgment. The Court of Appeal in the Bahamas, however, disagreed and held that the 3.5 months' notice given by the appellants was within the reasonable range. So in that context, the issue which arises on this appeal is whether the Court of Appeal of the Bahamas was entitled to overturn the judge's conclusion in relation to the length of the notice period. As you will have seen, the reasoning of the Court of Appeal is brief. It's contained in 5 or 6 paragraphs, paragraphs 26 to 31 of the judgment. And as I'll come on to explain, we submit that in those paragraphs, the Court of Appeal committed a number of errors and made a number of criticisms of the judgment which are not justified. But the overarching point that we make is that the learned judge at first instance conclusion that 15 months was a reasonable period was not a conclusion that was plainly or demonstrably wrong. Now, with that introduction, I'm going to address you in the following way. I'd like to start by saying something briefly about the relevant legal principles. Secondly, I'd like to spend a bit of time taking you through the learned judge's judgment. I know that you will have read that carefully, but I do want to show you the evidence that was adduced before her and the findings of fact that she made, since those findings were the foundation of her conclusion that 15 months was a reasonable notice period. And by showing you the judgment, that will set the scene for the submissions that I'll come on to make under the grounds of appeal. And then thirdly, I'll explain the 5 errors which we respectfully submit were committed by the Court of Appeal, and I'll deal with the points made by my learned friends in their written case. And as a preliminary point, I would just like to note that it's striking that in relation to 3 out of the 5 grounds of appeal, my learned friends seem to support the Court of Appeal's criticisms of the judge by reference to reasons that were not relied upon by the Court of Appeal itself. In other words, they appear to recognise, at least in relation to some points, that the reasoning given by the Court of Appeal was unsound. If I can turn to the legal principles, I'd just like to make 5 short points at the outset. First, the question of what constitutes a reasonable notice period is to be determined having regard to the facts and circumstances as at the time when the notice is given. That's common ground. Second, what constitutes reasonable notice depends on the particular facts of every case. In other words, the ultimate conclusion that may have been reached in other cases is, in my submission, of limited assistance. It's not right to do a comparative exercise, as it were. Third, whilst the length of notice is a question of fact in every case, the authorities have tended to recognise particular factors that are relevant to consider. We've set those out at paragraph 17 of our written case, and I'll show you in due course the Alpha Lettings case. But those factors include, for example, the degree of formality, the issue of whether capital expenditure has been incurred, for example, whether there ought to be sufficient time to allow, say, the distributor to recoup any investments made. Also, the amount of time it will take the party objecting to the termination to find alternative arrangements. And also, one of the factors which is relevant is the length of the relationship. I accept in Alpha Lettings it was said not to be a critical factor, but the Court of Appeal did accept it's a relevant factor. And we do, with respect, submit and stress that the length of the relationship is indeed a relevant factor. I mean, if one takes a step back and asks the question, as at the date of the notice, what would two commercial parties consider to be a reasonable period, so an objective question at the date of the notice, we do respectfully submit that the length of the relationship will be relevant to the impact that termination is going to have on the parties. And so we do submit that here, the fact that the parties had had a successful relationship for 40 years is important. The fourth legal point is that although the length of the notice is to be assessed in light of the facts and circumstances at the time the notice is given, that doesn't mean that the circumstances at the time of the contract are irrelevant. And the reason for that is because the implication of the requirement to give reasonable notice is intended to serve the common purpose of the parties, and the common purpose for which the notice is required is a matter to be determined at the date of the contract. Now, in this respect, I'd just like to very briefly show the Australian Blue case.
In this case, there was no evidence, was there, relating to the time of the contract?
There was no direct evidence, but as I'll come on to show you, the learned judge made an inference as to what the parties would have intended as at the date of the contract.
On what basis?
On the basis that she said this was a substantial agreement based on the evidence that she'd heard. It was 40 years, and she said it had a high degree of formality.
But how does that refer to the earlier period of the formation of the contract? That's looking at events at the end.
Well, can I show you the Australian Blue case? Because in my submission, what the Australian Blue case shows is essentially a default position that the parties desire to cushion themselves against sudden change. In other words, that's something which the learned judge was entitled to take from Australian Blue as a principle of general application. The default position is...
Yeah, well, if there's a requirement of a reasonable period of notice, that presumably is precisely for that purpose.
Exactly.
The parties cushion themselves against sudden change.
Exactly. Exactly. In a sense, in my respectful submission, it's a common sense conclusion that one reaches.
Is the reasonable period of notice always going to be the same from either side, or might there be a different reasonable period for the supplier to give to the distributor compared to the reasonable notice of the distributor wants to terminate the agreement?
Well, in my submission, the question is, when one's asking what is the reasonable period of notice, one's asking that question against a particular notice of termination having been provided. So obviously the reasonable notice period needs to be one that takes into account the position of both parties. I'd accept that. But the facts and circumstances pertaining at the time of the notice may well include whether that notice is being provided by one party or the other. Because one has to take into account the facts that have led to the termination, and therefore it may be a relevant question as to which party is seeking to terminate. But I do accept that when one's asking the question, what is the reasonable notice period, one has to have regard to the position of both parties. But the reason I just wanted to show you Australian Blue is because, although I say it's a common sense proposition, one of the arguments that we'll come on to later on the grounds of appeal does involve this question of common purpose. So if I could just show you, it's a very brief passage. The relevant page of the bundle is 1064, because most of the decision is concerned with whether or not there was a requirement of reasonable notice in that case. The only passage that I'd like to show you at this stage is on page 1064, in the judgment of Lord... It's 1064 in the hard copy. I think it's, if your lordship is using the PDF, it's 1071. I think the PDF numbers are...
PDF numbers, there's a mismatch between the electronic bundle and the...
They're out by 8 pages, as I understand
PDF,
it.
yes, the 7
I apologise.
pages, I think, yes.
I'm working in hard copy. It should be 1064 in the bottom right.
Well, we only have electronic copies, so you'll need to give us the electronic.
Well, we have to add 7, I think. You have to add 7 every time, I think, you refer to a document.
Yes. Do your lordships have its internal page 99? 1071 of the electronic bundle. And Lord Devlin says it's the passage starting, the question whether a requirement of reasonable notice is to be implied in a contract is to be answered in the light of the circumstances existing when the contract is made. And then further down, about halfway through that passage, you'll see the implication of reasonable notice is intended to serve only the common purpose of the parties, whether there need be any notice at all, and if so, the common purpose for which it's required, and matters to be determined as at the date of the contract. The reasonable time for the fulfilment of the purpose is a matter to be determined as at the date of the notice. The common purpose is frequently derived from the desire that both parties may be expected to have to cushion themselves against sudden change, giving themselves time to make alternative arrangements of a sort similar to those which are being terminated. And then towards the bottom of the page...
I mean, that must depend on the circumstances.
Yes, well, he says the common purpose is frequently desired. But then the second passage I'd like to show you is just about 3/4 of the way down. You'll see that on the facts of this case, do you see the sentence beginning, their lordships cannot infer as the common purpose of any requirement of reasonable notice anything more than the ordinary purpose, time on the one hand for the appellants to deploy their labour and equipment profitably elsewhere, and on the other hand for the respondents to find another licensee. And so what I rely on is the reference to the ordinary purpose, which I say is essentially the basic point, that the reason there is a requirement of reasonable notice is because the ordinary common purpose, what I described earlier as the default position, is that there needs to be time for one party to deploy their labour and equipment profitably elsewhere, and on the other hand here for the respondents to find another licensee. So that was the fourth point on the law that I wanted to make as regards common purpose. And then the fifth and final point at the outset was just to make the point, which again is common ground, that a decision as to what constitutes a reasonable notice period, whilst it's not an exercise of discretion, nevertheless an appellate court shouldn't disturb the finding of a trial judge unless the judge has erred in principle or reached a conclusion which is demonstrably wrong, and that's been recognised in 2 of the Court of Appeal cases in the bundle.
That means outside the range of reasonable notice periods.
Yes. I was going next to show you, we'll go through the first instance judgment, just because, as I say, it's important to see the findings and the evidence that was adduced before the judge, because we do say, for example, on the question of formality, which is our ground 1, we do say that the Court of Appeal failed to grapple with some of the judge's findings on formality, which obviously were significant in the context of her decision as to the reasonable notice period. The first instance judgment starts at page 100, 99 of the PDF. But I want to take this relatively quickly because I know that you will have read this. I wanted to start at paragraph 8. Which is 103.
Well, we do have this in
hard copy.
In hard copy.
I'm very grateful.
So paragraph
8,
that's
it's 96.
hard copy 96.
I'm very grateful. Paragraph 8, so this is the section starting the background, and some of the facts, she says, are agreed between the parties. To the extent there's any departure, then what's expressed must be taken as positive findings of fact. At paragraph 9, the finding that the agreement was entered into in 1975, and she says the distribution agreement between the parties was never reduced to writing. However, it was agreed informally that CBL would have the exclusive right, and I'll come back to that, reference to informally. That's relied upon by my learned friends, but in fact it's clear from subsequent passages in the judgment that she goes on to find that it was a formal agreement, notwithstanding that it hadn't been reduced to writing.
Was there some formal document with agreed facts? Or
I'm sorry.
was there a formal document of agreed facts?
In the court,
Yes.
first instance.
Which he says they're agreed between the parties.
I will double check. I'm not aware that there was a formal document,
Right.
but I will double check.
But over the 40 years, was it right that Anheuser-Busch did not supply its products to any other distributor in the Bahamas?
Yes, that's common ground that it was an exclusive.
And that was abided by?
Yes, it was exclusive in an asymmetric sense, in the sense.
Yes.
Exactly. Paragraph 10, you'll see the judge refers to there being terms of the agreement. So although it wasn't reduced into writing, the judge finds that there were terms, and you'll see what those terms are. But there is, in my respectful submission, some detailed terms to this agreement, notwithstanding that they weren't written. And then, just like to try and take this quickly, but there are quite a few passages that are important to as a run-up to the submission. So paragraph 13.
But just those terms, they were terms from the outset, were they? Or
Well,
are we talking about a particular point in time?
well, in my submission, that's the judge's finding is that these were terms throughout the period. I mean, there is reference later in the judgment to the terms having evolved in two respects. Yes. But for the most part, according to her findings, these were the terms from day one, as it were, so over the 40-year period. And this is important when one comes, obviously, to the submissions on formality, because we do rely on the fact that there were these detailed terms. That was a matter that was the subject of evidence before the judge. I'll show you that in a moment. Paragraphs 13 to 15, you'll see that BHL had allocated significant resources. It had in place a guarantee by way of security in the form of a letter of credit. The parties worked well together for over 40 years. And 15, BHL allocated specific human resources, including a senior brand manager and about 3 to 4 employees dedicated to the ABI.
The guarantee is hardly a significant resource, is it?
Well,
what's the cost of that going to be? Not very much.
Well,
It's an exposure, I agree, but
yes. Well, I mean, the learned judges, in my submission, that's a finding that she's made. I think the allocation of significant resources is a reference not only to the guarantee, but also she comes on to explain in 15 the specific human resources.
right.
So are these pointers towards formality, or are they pointers towards investment by the distributor, or both?
Well, the way, I'll come on to show you, in my submission, the way that the judge has approached this is that the points here, and I'll come on to show you some more points of a similar nature, they feed into her findings in relation to formality. There's a specific point about capital investment and the warehouse, but what the authorities say about investment is that one has to disregard, as it were, ordinary and recurring expenditure and focus only on capital investment, which I accept. But what I do say is that these sorts of points are relevant to that question of formality, because if there is resource, according to the judge, significant resources being allocated, then that would be relevant to formality. Then I just wanted to turn next to the section in her judgment, which is starts at paragraph 39. You'll see it's the evidence. And the reason I just want to show you these passages is so that you can see the evidence that was adduced before the judge. So, for example, paragraph 46. So this is dealing with the witness on behalf of ABI at trial, Mr. Giuliano. You'll see at the end of 46, he agreed that BHL bore 50% of the marketing costs for the ABI brands. and 47, he wasn't personally aware of the specifics, but it wouldn't surprise him if there was a senior manager dedicated exclusively to the ABI brands. And then the judge goes on to say, having a person behind the brand is the kind of support he expects from the distributors. And 48's a similar point. In general terms, what's expected is to have a structure in place allocated to support the development of their brands. He acknowledged the distributors would need the basics to support the brand, and so on. So that's it, the ABI witness. And then, if I could turn to the factual witness that gave evidence on behalf of BHL, you'll see the judge refers to him at paragraph 56, Mr. Mulder. And you'll see at 59, what I mentioned earlier, that he stated that the terms were as follows. So that was her finding in relation to the terms of this agreement were actually based on the factual evidence given by Mr. Mulder.
Who joined in 2018.
That's right, that's right. That he said that he had been briefed by Mr. Nevin, who had been the managing director previously. You'll see that at 57. But your lordship's obviously right. I mean, he wasn't there in 1975, but this is what he said in his witness evidence and was accepted.
But there are no challenges made to those findings of fact.
Exactly, my lord. And no, exactly, my lord. No challenge. And in fact, the Court of Appeal doesn't say that the judge was wrong to make any such findings. So for current purposes, in my submission, the board should proceed on the basis of these findings that were made by the judge. And continuing with Mr. Mulder's evidence, you'll see paragraph 60. In order to ensure the efficient distribution, it was also agreed that BHL would allocate, and it did allocate, substantial resources. And then a reference again to the specific human resources. So in other words, this was essentially common ground between the witnesses, although Mr. Giuliano said he couldn't speak to the specifics. Mr. Mulder did. And then 61, a reference to the termination having had an adverse effect on the business. They've not found an American beer that covers more than 15% of their portfolio, and he stated that brand loyalty and brand impact had been adversely impacted, and that's brand loyalty and brand impact to BHL, and you'll see that because of the reference in the next sentence, for example, those two beers complemented their portfolio. Paragraph 64 is common ground. That there's a reference there to the 15% of the beer portfolio. And
So what do you say as at the time of termination, the percentage of the beer portfolio? Well, I've seen figures 10%, 15%. Is that to do with whether you're talking about the percentage of beer or the percentage of overall drink? Or
yes, I'll show you the 10% reference.
The 10% is beer and wines.
It's
The
overall
15% is beer alone.
Exactly. Exactly. And just for your, I'll come to it, but it's that's explained at paragraph 83, the 10% figure. So I think I was just about to show you 69 and 70. So Mr. Mulder explained there should have been at least 3 to 4 dedicated people for the ABI brand. And 70 is the improvement to the refrigerated section used to improve the quality of their wine and beer products. And he described in 71 the distribution agreement as being fixed and formal for 40 years. That's obviously something that then gets picked up by the judge. And the reason I'm taking this slowly at this point is because these are important findings in my submission. When we come to the argument about formality, we say, just to foreshadow the submission, we say formality is a question of substance, not form. And so that's why it's important to understand the factual findings which underpinned the judge's conclusion as regards formality.
He was saying the terms change.
Yes, but I'll come to that in a moment because the judge deals with that point as well. The judge makes an express finding that notwithstanding to I think it was 2 amendments to the terms. Notwithstanding that, she says that she finds it was a formal agreement.
Was the judge's use of the term fixed and formal something that was picked up from the witness's evidence, do you know?
Well, I don't know, other than I can see at 71 that that's what she says Mr. Mulder was saying, and she goes on later.
I wondered about that.
Yes, it may well have been.
It may well be in his phrase.
Exactly, but in my submission, nothing, as it were, turns on that particular point, because she makes her own findings. 73 is just to show you that the other witness who gave evidence in front of the judge was Mr. Townend of KPMG. And I know you will have looked at these points, but at 76, his evidence was that there was a loss of $2.3 million a year.
That's gross margin.
Yes. And 83, just to show you, in light of my lady's question as regards the 10%, you'll see at the final sentence of 83, 10% of BHL's overall revenue. And then the final paragraph.
I see. So all they do is sell, I thought they sold spirits as well.
They do beer, wine and spirits. I think 10% overall revenue. And the final paragraph in this section on the evidence is 86, where she says that she prefers the expert evidence of Mr. Townend on the financial impact caused by the loss of the distribution agreement. She doesn't agree with him that it would take at least 3 years or potentially longer to replace the lost revenues. And then she goes on to find in the final sentence, the loss, or the penultimate sentence, I apologise, the loss in revenue was effectively felt in the first year of the termination of the distribution agreement. And then, if one then moves to the section beginning at 97, which is headed discussion, this is where the judge starts to make findings of fact. So at 106, you'll see that Mr. Jenkins was submitting, second sentence of 106, the loss is barely noticeable, and then he referenced the following, and in A, there was no evidence of any measurable dip in profits following the termination. So that's the position that ABI were advancing in front of the judge. And she finds, you'll see at the end of A, for my part, this evidence stands uncontroverted. That's the evidence of Mr. Townend, and it's the only evidence available. It's also difficult in these situations to show actual loss because of the very nature of the business, but she's accepting what's...
So where are you reading from them? So
the final 2 sentences of 106A.
Oh, yes.
So I was just showing you that Mr. Jenkins was arguing that there's no evidence of any measurable dip in profits, and what the judge says is, in fact, she accepts Mr. Townend's evidence, which was uncontroverted and the only evidence available. And similarly, at 106C, you'll see Mr. Delaney, Queen's Counsel for BHL, was at pains to emphasise the human resources that were dedicated. His evidence on cross-examination, Mr. Mulder's evidence, that a senior brand manager and about 3 to 4 employees worked solely on AB and InBev brands, no documentary evidence was adduced. However, I found Mr. Mulder to be credible on this point. So again, factual findings by the judge in this section. And a similar point in relation to the next subparagraph D, as regards the capital cost in recent years. So in recent years, there had been an improvement to the refrigerated section, and she says that she finds Mr. Mulder to be a credible witness on that point as well. I want to show you E, because this is something that comes up in the grounds of appeal. So at E, she's referring to a managing director's report of Mr. Nevin, and you'll see the underlined text. And that underlying text is not referred to by the Court of Appeal, although they do criticise the judge in this respect. So just want to highlight that. And then you'll see, if you move forward to 107, Mr. Jenkins argued that the terms of the distribution agreement were not fixed and formal, as there had been changes to the payment terms. And the correspondence shows that the requirement for a guarantee was not always a part of the agreement. And then the judge goes on to say towards the end of the paragraph, I do not agree with Mr. Jenkins that because the terms changed over time, the distribution agreement was not fixed and formal. In my opinion, these changes were not substantial, and such changes do not negate the fact that the relationship was a long-standing one with fixed terms and conditions. Indeed, it was a fixed and formal, healthy relationship.
Well, whether or not one uses the word formal, is there any dispute between the parties that the relationship was a long-standing one with fixed terms and conditions?
Well, you can see what Mr. Jenkins was arguing at 107.
Yes.
But for present purposes, these are findings by the judge, and we can proceed in my submission on the basis that these were fixed terms and conditions.
Because I really wonder if very much will turn the phrase fixed and formal at the end of the day.
Well, the reason, as I try to explain, the reason this is relevant and the reason I'm taking a bit of time
Well, I know, because of what the Court of Appeal said.
on formality.
Yes.
And if my submission is accepted, which is it's a question of substance over form, then we say the judge has actually made very detailed findings of fact that the agreement, although not reduced to writing, had a high degree of formality. And so that's why I just want to show you the way in which the judge approached this question.
Well, again, the use of formality may not be helpful. The fact it's a long-established relationship with terms which didn't vary.
Yes.
Substantially.
Yes. Now, none of this matters if you accept my learned friend's point that because it was not in writing, it's not to be treated as formal within the meaning of the Alpha Lettings decision. And therefore, that has a bearing on the length of
I
notice.
think the formality is not only the duration of the terms, but the nature of them, the budgeting and the meetings and it wasn't the kind of relationship where they said, well, if we want a couple of crates of your beer, we'll let you know and then you send it to us and we'll pay for it. It wasn't a sort of ad hoc relationship. It was structured, if you can say that.
Well, that's another way of pushing it. Exactly so. And in fact, I'll come on to show you, by way of example, another case where it was there was an agreement which was said to be quote unquote informal, but it was genuinely an ad hoc agreement with none of these terms and none of the structure in place. I mean, it's all, we say, a spectrum between completely informal agreements and ad hoc agreements, and on the other hand, long, detailed written agreements. And the question is, where are you on that spectrum? But if I just perhaps try to finish off on the judgment, 114 is the judge's analysis and conclusion. That's section 114. And this is really the key section. Although she's already, by this stage, made some findings of fact that I've shown you, you'll see 118, simply put, they entered into a distribution agreement nearly 40 years ago. The relationship between the parties was fixed and formal, so in quotation, so she has probably taken that phrase
That was my understanding.
from the witness, and despite the plaintiff's contention that it was not, they were at pain to argue to the contrary, and then she says that they held fast to two somewhat inconsequential events, namely, Roman 1, the changes to the payment terms, and the requirement in 1989 for a guarantee. As Mr. Mulder correctly asserted, in a relationship lasting for 40 years, terms are bound to change and evolve. That said, it doesn't necessarily mean that the relationship between the parties was not fixed and formal. Indeed, the relationship was fixed and formal, and both parties enjoyed a healthy and profitable relationship for 40 long years. 122, she refers to the fact that Mr. Delaney, on behalf of BHL, emphasised the long relationship. BHL was substantially financially reliant, and he submitted that Mr. Giuliano conceded that the loss of brands represented a material component. And 123, he further stated that BHL had substantial commitments, costs and expenses regarding distribution and marketing, and devoted substantial resources.
But these are submissions.
Well, they are submissions, but they're actually in the section which is...
I know, but then
Well, I'll come on.
still submissions.
Well, I'll come on because she expressly, in my submission, she comes on later to accept them. The next paragraph, and this is a very important paragraph, is 130. So despite the fact there was no written contract, Mr. Mulder's concession, he didn't know whether the relationship was fixed and formal prior to 2015. That's the point about whether he'd been there throughout the period. Roman 3, the payment terms have changed. The relationship was a fixed and formal one. The fact that it existed for nearly 40 years speaks volumes. And then she says, in addition, the distribution agreement had a high degree of formality. And then you'll go on to see the points, A through to F. And we say this is a very important finding because the Court of Appeal, I'll come and show you this in a moment, but they fail to grapple with paragraph 130. They don't refer to it anywhere in their judgment, and they certainly don't deal with it when they criticise the judge for finding that the agreement was formal. 131, she says no doubt BHL would need to take time to find another supplier. And 133, she doesn't accept the plaintiff's submission that the loss was barely noticeable. And we've seen that already. 134, in my judgment, BHL has suffered as a result of the termination. And then 135, I agree with Mr. Delaney that any attempt by Mr. Jenkins to minimise the impact were then put in proper context and dismissed by Mr. Mulder. So in other words, she's preferring Mr. Mulder's evidence as to the impact over the submission of Mr. Jenkins. And then you'll see what is quoted at 136 from Mr. Townend. That's the KPMG expert. That's the 2.3 million figure again. And 137, the plaintiffs attempted to diminish the value of his evidence. However, Mr. Townend offered a reason. So, and then 138, and importantly, there was no expert evidence adduced by ABI. So that's why at the end of 138, Mr. Townend's expert evidence stands uncontroverted. And as I stated earlier, he appeared to be the only witness who brought some objectivity to these proceedings. So she's accepting his evidence, albeit rejecting his assumption that it would have taken 3 years. She does accept that the loss was 2.3 million in the first year.
But I'm not quite sure why Mr. Townend's proffered reason is not actually evidence that the loss was only quite short, because what he's saying seems to be there was no point going back because by that time any lost profits from the distribution agreement would have been offset by increased profits that arose because of the divorce from ABI. So isn't his evidence, in fact, that after December 2016 one would have expected the actual effect on the bottom line to have been removed?
Yes, I think the difficulty that I think the way the judge deals with this is to say that essentially there was no expert evidence from ABI, and the evidence from Mr. Townend was the best that she had. I mean, that's why at the end of 138 it stands uncontroverted, and he was the only objective witness she found. But I think I showed you the earlier passage where, I think it's yes, I think it was in 106A, going back to 106A, she said that it was the only evidence available, and it's difficult in these situations to show actual loss because of the very nature of the business. So I accept, as it were, well, I understand why you've asked that question, but the way the judge dealt with it was to say, well, this is, as it were, this is the best I've got.
So what's the finding you say she made?
The finding in relation to this point,
Yes.
that there was 2.3 million of loss in the first year.
What do you mean by loss?
Well, it's the finding she's making here in my submission is that there is a loss in the first year because she's rejected the assumption that it would take 3 years to recoup.
It's a gross margin.
Yes.
The gross margin is the distinction between the it's the distinction between the income gained from selling the product and the cost of purchasing the product. It's not taking into any account the operative costs of selling the product. So it's not a measure of profit.
The debate before her was essentially the ABI trying to minimise the impact. She says, I have evidence from Mr. Townend, he's the only objective witness.
Yes, but it's gross margin.
Yes,
You
no,
accept that.
I accept that.
It's not bottom line.
I do accept that. If we then go to
her finding is that there was 2.3 million loss of gross profit in the first year following termination.
correct.
But she doesn't make any finding as to any loss after that, because Mr. Townend says after that they would have boosted their sales of competing.
Yes, and in fact she expressly rejects the idea that it would have taken 3 years.
Yeah.
And 142 is actually where the judge then draws together all of these points. So 130 is a key paragraph for the formality point, where she draws together the evidence on formality. And then 142 is a crucial paragraph, because that's where she expressly refers to the particular factors which she has considered to be relevant in reaching the 15-month conclusion. The relationship between the parties spanned a period of nearly 40 years. Point 2, despite the 2 changes, the relationship was fixed and formal. 3...
Can I just ask on 3?
Yes.
She says that towards the end of there, each side would be afforded sufficient time and compensation to make alternative arrangements. What's the significance of the reference to compensation?
Yes, this is actually a point which arises directly in relation to one of the grounds of appeal, because we say that's a reference back, or it's at least consistent with the Australian Blue principle, that there needs to be a cushion against, as it were, a sudden termination. The other side, my learned friend says that she goes too far by referring to, I think what she says in relation to Australian Blue, I'll come to this.
Yes, but I mean sufficient time would have done it, wouldn't it?
Yes, yes.
I mean, and
yes, no, I accept that, but the point she makes elsewhere is that there needs to be, as it were, sufficient time without damage to the other's business interests.
Without damage to the other's business?
Yes, you can see that she goes on to say each side would be afforded sufficient time to make alternative arrangements without damage to the other side's. So I do agree.
Each side would be afforded sufficient time and compensation. That must be the person to whom the notice is given, isn't it?
I accept sufficient time would be enough to ensure there's no, as it were, damage, I think she's essentially saying.
I don't know I'm not quite sure what she's saying here.
Well, this could be quite important, because if she is saying that the period of notice has to be fixed with a view to avoiding loss suffered by the party to whom notice has been given, I wonder if the case law supports that proposition.
Well, I think, to be fair to the learned judge, I think she may be referring to remuneration, in the sense that the relationship would continue during the notice period. And so it's time, by way of notice, but also the compensation would be continued remuneration during the notice period to make alternative arrangements. But can I come back to that?
It's during that period that there won't be damage to the other parties.
Exactly, that's the point. I'll come back.
To say to, yes.
I'll come back to this in more detail, because I haven't shown you what she says in relation to Australian Blue, because that's the subject of one of the grounds of appeal. So we say those points in 142 are key in terms of explaining where the judge arrived at.
Well, it's unfortunate then that they're not clearer.
It's perhaps worth drawing attention to paragraphs, going back a bit, paragraphs 80 and 81, on the point that was raised a few minutes ago about gross profit margins. In paragraph 80, she records that Mr. Townend was asked whether he'd been engaged to analyse actual loss, and there are then various factors listed in the bullet points which made it, he said, very difficult to determine the impact of the loss of a distributorship. And in paragraph 81, when pressed, he said it would be almost impossible to measure quantum of losses because of the many factors that would affect it.
I'm grateful. Having shown you the judgment at first instance in some detail, now I'd obviously like to turn to the grounds of appeal. And we have 5 grounds of appeal. The first one concerns paragraph 26 of the Court of Appeal's judgment. If you're page 88, if you have that in hard copy, page 88, paragraph 26. And as I say, that the Court of Appeal's reasoning is contained in really the paragraphs from 26 to 30. And then at 31, they draw together their reasons. But we have essentially a criticism in relation to each of the paragraphs from 26 through to 30. Now, in 26, they're dealing with formality. I'll come to the Alpha Lettings case in a moment to show you that. But you'll see at the end of the bottom of the page, the quote from 31 of Alpha Letting, one very important consideration will be the degree of formality in the relationship. So that's why the judge dealt with formality in the way that she did, and that's why the Court of Appeal is looking at formality in paragraph 26. Now, in the first sentence of 26, the court refers to the judge having said that the relationship between the parties was fixed and formal and a healthy and profitable one for both parties. They don't give a reference, but I believe that's a reference to 142, subparagraph 2. And they then go on to criticise this conclusion. And I'd like to make 3 points about paragraph 26. The first point is that the court goes on to say it is unclear what that means or the evidential basis for that. And in my submission, that criticism of the judge is wholly unfair because, in fact, as I've shown you, the judge made very detailed findings regarding formality, and that's paragraph 130 of her judgment with the 6 particular findings that she sets out at paragraph 130A through to F. And as I alluded to earlier, notwithstanding those detailed findings at 130, the Court of Appeal don't grapple with those findings at all. They don't even acknowledge what the judge found at paragraph 130. They only deal with the conclusion in 142.2. And so we say with respect, that's an unfair criticism, that it's unclear what that means or the evidential basis. Now, my learned friends say that the Court of Appeal was not interfering with the findings of fact. They say formality is a question of characterization. But we submit that the problem with that point is that they can't explain the Court of Appeal's failure to grapple with the findings. So the Court of Appeal here seems to proceed on the basis that it was entitled to interfere with the characterization because it was unclear what the evidential basis was for the judge's finding. And we say that premise was incorrect. So that's the first point we make in relation to paragraph 26. The second point is you'll see that the Court of Appeal go on to say the agreement was never formal. On the contrary, it was informal and never reduced to writing. And in our respectful submission, the error here is that the Court of Appeal is treating the question of formality as though the answer is binary. It's either formal or it's not. And moreover, the Court of Appeal is equating formality with a reduction to writing, which we say is wrong in principle. If I could show you the relevant paragraph in Alpha Lettings. Which I think can be found at 102 7 of the bundle.
I think it would be 1034.
I've added the page.
Pardon?
I think I've added the pages for the
Yeah, the
The
start
PDF.
of the case is at
1027. Yes.
Which, sorry, I thought you were referring to the particular paragraph.
Oh, the particular paragraph is 31.
Paragraph 31.
Oh, I'm very grateful. Yes, so 31 is the important paragraph on this question of formality.
Age?
1034.
And what Lord Justice Longmore says in 31 is, you'll see at 30 there's little authoritative guidance, and then he refers to two possible views. But 31, one very important consideration will be the degree of formality in the relationship. A completely formal agreement would probably have its own provisions for termination, so no problem about assessing a reasonable period for termination will arise. But the more relaxed the relationship, the less likely it will be that the law would imply a lengthy notice period. And then he goes on to deal with the evidence in that case. Now we say, in my respectful submission, it's actually obvious that what Lord Justice Longmore was envisaging was a spectrum, and he's just giving one example of a completely formal agreement, probably having its own provisions for termination. But then he goes on to say, but the more relaxed the relationship. So he's just giving one example, and he's not equating formality with writing, and we say it would be wrong to do so. In our submission, whether or not an agreement is in writing may be relevant to the question of formality, but it's certainly not determinative. There may be very long written agreements, but there may be some very short written agreements, and likewise, in relation to unwritten agreements, there may be ad hoc, very casual arrangements, and there may be some unwritten agreements with detailed terms and rights and obligations. And therefore, we submit the proper approach, and indeed the approach envisaged by Lord Justice Longmore, but in any event, the proper approach in principle is, in every case, to consider the substance of the relationship and the degree of formality.
Yes, it is significant that Lord Justice Longmore is talking about the nature of the relationship rather than the form of the contract.
Exactly so.
So you say there's a spectrum between the ad hoc and what Lady Rose describes as a structured relationship, and you say this is towards the structure there.
Exactly. That's really the nub of it. And if we are right, and there appears to be, as it were, a clear difference between the parties on this appeal, because my learned friends say that formality is essentially the same thing as writing, and they say we are actually wrong to submit that it's a question of substance over form. Now we say if in fact we're right that it's a question of substance over form, then the approach taken by the judge was correct, to consider, as she did, all of the evidence before her, and to conclude on the evidence that it was an agreement, albeit unwritten, but it had a high degree of formality. And I'd said earlier I would just show you another case, just by way of, as it were, an example to illustrate the spectrum. The Jackson case, which is in the bundle, is another agreement which was not in writing, but one can see that it was actually an agreement that was very different to the agreement in our case. That's 1164. And I stress, I'm just showing you this by way of an example to contrast the position. So if one looks at paragraph 10, you'll see from between paragraphs 10 to 17, there's the court is dealing with discussions about a written agreement, and you'll see at 17, in the event there appeared to be no discussions and no written agreement was signed. And then if one moves forward to 24, there was a question as to whether, notwithstanding that there was no signed written agreement, whether the written agreement still had some relevance. So the burden of showing that the parties acted on the terms of a written agreement which has not been executed lies on the party so contending. I do not consider that that burden has been discharged. In other words, the draft written agreement, as it were, fell away. And 25 is also similar. The stage had never been reached where the draft should govern their contractual relationship. So that meant that there was an informal, unwritten agreement, and one sees that in 31. There was an agreement in March 2005 whereby, and you'll see what the terms were in this case, agreed that the claimant should be sole distributors, implied term would supply the products in a timely manner and a good workmanship, and implied term that either party was entitled to terminate on reasonable notice. So we say that's quite instructive as regards, and you'll see at 44, when the judge goes on to consider what the length of notice should be, you'll see that the conclusion is, although both parties put forward their respective drafts, there was, in consequence, no great degree of formality. So the only reason I show you that is just to explain that if one's approaching this as a matter of substance, we say the judge was plainly entitled to find that, although it wasn't in writing, on these facts there was a high degree of formality. It was not, like in Jackson, a casual ad hoc arrangement with those very basic terms. And then the final point I'd like to make on paragraph 26 is a very short point, which is the Court of Appeal goes on to, if one goes back to paragraph 26, so I've dealt with the evidential basis point, I've dealt with the never reduced to writing point, and then they go on to say, indeed, the judge clearly stated, and they don't give a reference, but that's a reference to paragraph 9 of her judgment, which I showed you at the outset, where the judge said at the very beginning of the judgment that it was agreed informally that CBL had the exclusive right. And this is a point that is relied upon heavily by my learned friends. But as in my submission, one has to actually read the judgment as a whole, and it's absolutely plain from the other paragraphs that I showed you, 107, 118, 130, and 1422, that the judge goes on, once she's considered the evidence, to conclude that there was, in fact, a high degree of formality. So it would be wrong to seize upon that reference in paragraph 9. So those are the points on the first ground of appeal, and if formality is said by the Court of Appeal now for lettings to be a very important consideration, and we say those points in paragraph 26 are unfair criticisms of the judgment. The second ground of appeal...
Why is it a very important consideration?
Well, I would accept that that's what Lord Justice Longmore says, and as it were, I'm content to proceed on that basis, but I don't necessarily accept that's right in principle. No. I would say it's one
a relevant factor, but I don't see why it's more important than...
I would respectfully agree, and I would respectfully also say that Lord Justice Longmore doesn't actually attach enough weight to the question of length, which is the paragraph 32 of Alpha. So I agree that ultimately this is a multifactorial question. But if it is being said, and if one is proceeding on the basis it's a very important consideration, then we say, as the Court of Appeal did below, we say the criticisms are unfair. So the second ground of appeal relates to paragraph 28. And just, again, the Court of Appeal refers to what the trial judge said. So in her reasoning, the trial judge referred to the substantial nature of the agreement and suggested it's reasonable to infer that the parties intended that in the event of termination, each side would be afforded sufficient time and compensation to make alternative arrangements without damage to the other business interests. Now, they don't give a reference, but that is a reference back to a section of the judgment I didn't take you to earlier, so 126 of the first instance judgment.
I thought that was the passage that we looked at quite a lot, that reference to compensation.
I think we picked up the reference to compensation at 1423. I apologise if I did take you to 126, but the Court of Appeal is, although there's no reference, I just wanted to show you that's what they're referring to, 126 to 128 of the first instance judgment.
Well, they're actually quoting 28 from 142 subparagraph 3.
Yes, but the 142.3 is referring to the common intention of the parties and the substantial nature of the distribution agreement. And the conclusion at 142.3 comes from the analysis at 126 to 128.
Yes, that's right. Yes.
And at 126 to 128, you'll see that the judge is dealing with the Australian blue common purpose principle. So this is the point I started with, common purpose to be determined as at the date of the contract and the sudden cushion, or the cushion against a sudden change. 128 is the finding. Applying these principles, the common purpose for which the notice is required is a matter to be determined as at the date of the contract. Due to the substantial nature of the agreement, it's reasonable to infer that the parties intended. So that's the finding. And if one then, so that's the way in which the judge dealt with it. If one then goes back to the Court of Appeal at paragraph 28, you'll see that they don't refer to that section of her judgment, nor do they cite Australian blue. What they say is, that's what she referred to in her reasoning, and then the Court of Appeal says, I agree with the observations of the trial judge in Zymagorium, where he said at paragraph 165. And so the judge, the Court of Appeal doesn't explain why they're rejecting the judge's reasoning, but one can infer that what they're saying is because they agree with the observations of the trial judge in Zymagorium at 165, that's why the judge was wrong to refer, as she did, to the substantial nature and the common purpose and so on. But none of that's explained expressly. And the Zymagorium case, just like to maybe show you that. We have the Court of Appeal's decision, but one can see in the Court of Appeal's decision the judge's findings. And it's actually referred to extensively in the Court of Appeal of the Bahamas decision. Actually, I can take you back. It's probably faster just to show you the extract in the judgment that we're already in, because you'll see at paragraph 21, you'll see they refer to the Zymagorium case.
21 in what?
I'm still in the Court of Appeal of Bahamas judgment. Yeah. They refer to the Zymagorium case, and they say that it was a judgment that wasn't available to the trial judge. And they then quote from the Court of Appeal in Zymagorium. It's quite a long passage, which is why I think for this purpose it's sufficient for me just to show you what the judge, if you have, it's page 84 of the bundle, which if I show you page 83, so this is all an extract from the Court of Appeal in Zymagorium, and you'll see at the bottom of 83, paragraph 89 of the Court of Appeal's judgment, the judge considered the application of these principles and held as follows, 164 to 165. So what the judge, the trial judge in Zymagorium was doing at 164 and 165 was just weighing up what the factors were in that case and what the reasonable notice period should be. And you'll see the conclusion on 165 is bearing in mind these factors. The reasonable notice period in this case has to be a short one. And so...
But the Zymagorium case, that was an exclusive supply agreement in the sense that the supplier could not provide its goods to anybody else other than ZL. But was ZL limited to only distributing HOKs?
It considered itself, if you look at the finding at 164 164.4, if you see that on, if you're still in the Court of Appeal,
Yes.
the defendant indicated that it considered itself obliged not to do so.
So that's a very different thing, isn't it?
Yeah, well, absolutely. My submission is the first point is one can't read across anything from other cases. That's the sort of general point. But the more specific point I'm making at this stage is that insofar as the Court of Appeal, at paragraph 28, is referring to what the judge held in relation to common purpose and the Australian blue principle, we say it actually is incoherent to reject that part of the trial judge's reasoning on the footing that the Court of Appeal says, I agree with the observations of the trial judge in Zymagorium. Not only is that a completely different case, but the judge is actually undertaking a completely different exercise at that stage. I mean, the judge in Zymagorium at 165 is not looking at this common purpose cushion point from Australian blue. So we say, going back to paragraph 28, that the Court of Appeal was wrong. I mean, they don't explain this at all. They simply say what the judge referred to and they agree with the trial judge. But insofar as they are rejecting what the trial judge held because of what was held in Zymagorium 165, we say the Court of Appeal fell into error. It's just not an answer to the judge's reasoning. And my learned friends, in their written case, paragraph 39, they don't refer at all to that reference to Zymagorium. So they don't try to justify the Court of Appeal's reference to Zymagorium. Instead, they advance an entirely new line of argument, which doesn't feature in the Court of Appeal's judgment. Perhaps if one turns up their written case, paragraph 39, you have paragraph 39. They say it is paragraph 39 is page 59 of the bundle. So as I say, they don't seek to derive any assistance from Zymagorium. Instead, they say at 39, it's accepted that the Court of Appeal implicitly rejected the trial judge's inference of the common purpose. And then they say it's submitted that it would have been entitled to do so for the following reasons. So that's why I say they're advancing a new justification for paragraph 28. And just to deal with those points, in A, the trial judge provided no explanation as to how she arrived at her inference as to the stated common purpose, one that went well beyond the common purpose. Now, in my submission, that's not a fair point, because the inference was based on two things. It was based on her finding of fact that this was a substantial agreement in relation to which no challenge is made. So she says this is a substantial agreement, but she also takes from Australian blue what I described at the outset as the default common purpose. And that's what the judge was doing at 126 to 128. And then they say at 39B, the trial judge had no evidence as to the circumstances at the date of the agreement. And we accept there was no direct evidence as to the circumstances as to the date of the agreement.
Just going back to A, I think
Yes.
the point they're making is that the references to compensation and absence of damage to the other party's business go beyond what is said in Australian blue. And that's right, isn't it?
Well, I think that's. I was just about to come to that point, but we say that's not right, because essentially what one sees in the cases, the reason I took you to Australian blue at the outset was the reference by Lord Devlin to finding alternative similar arrangements and being able to deploy profitably elsewhere. So we say that it's. I accept that she's, as it were, perhaps used different terminology, but I don't accept that she's gone beyond what the case law says as regards the common purpose.
Well, this may be quite an important point. I mean, are you saying that the reasonable period of notice in the case law is that which enables the person against whom notice has been given to recoup the profits it otherwise would have earned if the agreement had continued?
Well, the cases referred to there being an orderly conclusion and time to find suitable alternative arrangements. I think the...
Yes, but that's far short of saying those alternative arrangements generate the level of profit
Yes,
that one
well,
enjoyed
no,
in the arrangement.
I'm not...
And yet, one could read the judge's judgment as based on the idea that such a period of notice had to be given to allow the possibility of recoupment of that profit.
I'm not putting it as high as that, but I am saying the cases refer to the slightly different, the way in which this point is expressed is slightly different in the cases. So in Australian Blue, there is a reference to the common purpose being that for there to be sufficient time to find alternative similar arrangements and for the other party to deploy profitably elsewhere. And in Alpha Lettings, the reference is to there being an orderly conclusion and the other party, I think, making substantial progress towards similar arrangements. So I'm not saying, as it were, the reasonable notice period has to be one that means no loss at all, not putting it that high, but I do say that what the case law demonstrates is there needs to be a reasonable notice period, not to have a, as it were, dramatic impact. The effect on the business cannot be one that's a significant loss or a material loss, because that's exactly why there needs to be a reasonable notice period. So ultimately, we don't accept that the judge has gone wrong in principle.
But she picked the period of 15 months because that was the period she thought the company needed to get back to its performance before the termination of the contract.
Well, my lord, that's not, in my respectful submission, that's not an entirely accurate summary of the way in which she's approached it. It was one point. I accept that the evidence of Mr. Townend was directly concerned with this period of loss in the first year.
She thought he had taken too long a period.
Well, yes, indeed. But even with the 1 year, 2.3 million loss evidence that she accepted.
2.3 million
gross margin.
of gross margin.
But that was only one of the grounds on which she held there needs to be 15 months. So I think it's not right, in my respectful submission, to say that was what led her to 15 months. I mean, one can see from paragraph 142 that there were a range of factors that led her to conclude that it needed to be 15 months as opposed to 3.5 months.
I mean, there's a kind of tension here, because during the reasonable notice period, unless they agree otherwise, they are bound by the continuing exclusivity terms of the distribution agreement. So there's a limit to what they can actually do to boost their other business or find an alternative supplier. Whether it takes a long or a short time to negotiate a replacement agreement to come into effect after the end of the reasonable notice period would depend on the industry. We don't really know here how long it would take to find another beer supplier.
Yes, I mean, there are two points which we say are different points. One is the extent to which there needs to be a cushion, and whether the judge has gone beyond the authorities, which we say she hasn't. Then the second point is, my lady, you're referring to what happens during that notice period, which in my submission raises the question about what the obligation is on the distributor during the notice period, which is the subject of our ground 3. But those are the 2 points, essentially, that arise out of my learned friend's paragraph 39. So they say the judge, the Court of Appeal was right. It would have been entitled to reject the judge's reasoning in this respect. And those are really the 2 points that they make in 39. So the first, I think I've dealt with, but the second arises more directly under Ground of Appeal 3. So if I turn to Ground of Appeal 3, which concerns, if one goes back to paragraph 27 of the Court of Appeal's judgment. The Court of Appeal criticised the judge. They say the judge doesn't refer to the fact there's no prohibition against Commonwealth Brewery selling its own products, or to the obligation by the respondent to use its best efforts to promote the appellant's products during the term. And then there's a quote from Alpha Lettings, paragraph 33. And I'd like to show you, or go back to what's said in Alpha Lettings at paragraph 33, because this is important. One can pick that paragraph up in the Court of Appeal of Bahamas judgment. It's at page 75. One just goes back. In the same judgment, you can see the full text of Alpha Lettings, paragraph 33. Now, so Lord Justice Longmore, at paragraph 33, says it mustn't be forgotten that every distributorship is a bilateral contract. There was some debate before us as to the appropriate implied obligation of a supplier in the position of Neptune, but in the end, both parties were prepared to agree that it was necessary to imply a term that Neptune would accept and fulfill orders placed by Alpha in respect to both standard and special valves. The existence of this implied term is, of course, of great importance when it comes to assessing any damages. And then he says, but there will have been a correlative obligation on Alpha, the extent of which was not debated before us, but is most likely to have been that Alpha were under an implied obligation to use their best reasonable endeavours to promote the sale of Neptune's valves. The concept of a party to a contract being obliged to use his best endeavours to promote the products of the other party after notice of termination is being given is difficult, and must also militate in favour of a shorter rather than a longer period of notice. And so, in our case, the Court of Appeal is criticising the judge for not having referred to this obligation to use its best efforts. Now, we say a few things about this. The first is, the point was argued before the judge, and at paragraph 108, she records the submission that there would have been a best endeavours obligation during the notice period. She doesn't go on to accept that submission or indeed make a finding about the obligation during the notice period. So paragraph 108, I can show you, this is actually now, I think, common ground, that there's no finding to this effect, but that's also clear if one just looks at 108. It's clear that...
So she doesn't address it one way or the other.
Sorry, my lord.
She doesn't address it one way
Exactly,
or the other.
exactly. So that's the first point.
Isn't it implied by law, or is it implied as a sort of, yes, of course type obligation? Or?
No, my lady, in my submission, if such a term exists, it would be implied in fact. It wouldn't be implied, as it were, as a matter of law, that there's a best endeavours obligation. But just taking this point in stages, the first point is it's common ground that there's no finding in the judgment one way or another. The next point is that the Court of Appeal in paragraph 27, in my submission, it's doing one of two things. It's either proceeding on the basis that the judge did make a finding that there was this obligation but didn't refer to it. And as I've explained, that's not the position. She didn't make a finding, she just didn't address it. So if that's right, then the other possibility is that the Court of Appeal itself here in 27 is finding that there was, during the notice period, a best efforts obligation, and so the judge has failed to take account of the fact that the Court of Appeal's view is that there was this obligation. And we say the Court of Appeal was not entitled to make a finding of its own that there was a best endeavours obligation. And we make a couple of points. The first is that if they are making a finding, it's based entirely on, or solely on, Alpha Lettings. They're not saying, in the light of particular evidence,
So your clients were saying, there's a reasonable notice period, I think they were saying 3.5 years,
That's right.
during which
They didn't have to
ABI
make a
were not entitled to supply their goods to any other distributor in the Bahamas, but that BHL was not under any obligation to make reasonable endeavours to sell their product to the retail market.
Well, well, as you know, the judge rejected the 3 years point anyway. So the question is
Yes,
what...
I'm just looking at what your case was.
No, but, well, it was certainly not accepted that there was a best efforts obligation during that period. I'm not sure...
I mean, the contract would have had a best endeavours implied term prior to the notice, would it?
Well, that you've preempted a point I'm going to make. Any obligation, I don't necessarily accept, I'll come on to this, that it was a best endeavours obligation, but I do agree that this question needs to be assessed at the time of the contract.
Yeah, but the point is, during the contract, before termination, would your client have been under an obligation to use best or reasonable endeavours to sell ABI's products?
Yeah, well, one of the difficulties, this point was not pleaded, and I'm not aware that my
But
client...
isn't it in the nature of the distribution agreement that that must be the case?
Yes, but there's a crucial distinction, my lord, in my submission, as between the best endeavours obligation and a reasonable endeavours obligation. I obviously do accept that my clients would have owed some sort of obligation. I do understand Lord Justice Longmore saying it's a bilateral agreement and there must be some obligation to do something. One can't simply sit on one's hands. I obviously accept that. But what I don't accept is that it's necessarily a best endeavours obligation. And this is important because, first of all, if one looks at what the Court of Appeal was saying in Alpha Lettings, in my submission, that this is the only basis on which the Court of Appeal of Bahamas has said there was a best endeavours obligation. They haven't said, we've looked at the case in the round and given all of the facts and so on. They've said, because of Alpha Lettings, paragraph 33, there was a best endeavours obligation. And the difficulty is that in Alpha Lettings, you can see that there was in fact no argument about this. And what Lord Justice Longmore says, in one place he talks about, let's go back to paragraph 33, he says the extent of that obligation on Alpha was not debated, but is most likely to have been that Alpha were under an implied obligation to use their best reasonable endeavours. And then he goes on to say the concept of a party to a contract being obliged to use his best endeavours to promote. So the first point is to understand in Alpha Lettings, A, there was no argument about it, B, there seems to be references to the best reasonable and then best endeavours. And we say one of the points what one needs to take account of as to whether this is in fact a best efforts or best endeavours obligation, in the context of a non-exclusive arrangement where the parties on day one would have known that the distributor is free to supply other products, then in fact, whether or not there's a best endeavours obligation becomes quite problematic as opposed to a lower obligation such as reasonable
I would have
endeavours.
thought the other way round. If the distributor is free to sell competing products, but the supplier is not free to supply anybody else in the territory, I would have thought that point that the supplier would be very keen to make sure that there is a best endeavours obligation, otherwise it's a lose-lose for them.
The difficulty is if you've got a number of competing products, how do you fulfil best endeavours for each of them?
That's exactly the point.
Because it's necessarily going to be damaging the position of others.
Moreover, yes, my lord. Moreover, in this case, it's BHL was a distributor of other products, but also a brewer itself.
Well, I mean, it's owned by Heineken, and it's obviously promoting and distributing Heineken products.
It is
likely to be in competition with Budweiser.
Exactly. So, my lady, your ladyship's right, but your ladyship, with respect, is looking at it from one end of the telescope. From the distributor's point of view, it would be extremely problematic in my submission to commit to a best endeavours obligation where it has, and this is a point known to both parties, rights and obligations vis-à-vis other suppliers and its own products as well.
But does this really matter? whether it's best or whether it's reasonable endeavours. I mean, you accept, and I think you're bound to accept, that because you were the exclusive distributor, there must be an obligation of at least reasonable endeavours. But doesn't the point still hold?
Well,
here?
in my submission,
Need to be best endeavours.
in my submission, just taking it in stages, it does matter whether it's best endeavours or reasonable endeavours. I mean, one actually sees in a decision of Mr. Justice Popplewell, the best endeavours obligation is referred to as a duty of loyalty, which we say is actually something completely different and in fact has its own issues attached. But just focusing on best endeavours, we say the reason this does matter is best endeavours would require a party to actually subordinate one's own interests in certain cases. Reasonable endeavours doesn't. And so to the extent Lord Justice Longmore is envisaging problems during the notice period, we say on proper analysis those problems are much less likely to arise in relation to a reasonable endeavours obligation.
Well, can I put it this way? Because I'm not sure that whether it's best or reasonable matters. Whether it was best or whether it was reasonable throughout the contract, the distributor would not be entitled just because notice had been given to alter its performance, would it? It would still have to allocate to ABI the staff that it was allocating to ABI because it was still performing the contract and was being supervised by ABI, as the judge held in paragraph 130 about agreeing marketing plans and so on.
Yes. I mean, the basic point is, I think what's being referred to is, should there be a shorter or longer notice period? Well, let's look at the obligations between the parties during that period. And it's obviously right that the relationship will continue during that period. But in my submission, in the context of a 40-year relationship, and if one leaves aside best endeavours, because I don't accept that one can just take from alpha lettings and superimpose into our case that there was in fact a best endeavours obligation, let's just assume it was a reasonable endeavours obligation. I don't accept that in fact there is a real problem caused by the fact that one would need to continue that 40-year relationship for a further 15 months as opposed to 3.5 months. And that, in my submission, is what this boils down to. Yes, there will need to be a continuation of the relationship by definition, but what I don't accept is, as it were, the hard-edged point that seems to be referred to by Lord Justice Longmore, where he said, well, there must be a best endeavours obligation, and if there's a best endeavours obligation, that must militate in favour of a shorter period. I simply just don't accept actually either of those stages of analysis. And so we do say that the Court of Appeal was wrong in this respect to criticise the judge for not referring to this best efforts obligation.
But would you accept that during the period of notice, whatever it was, the distributor would be required to devote the resources which it had devoted to the ABI contract before the termination?
Yes.
Yes.
But it's only one factor. That's the other point. This is only one factor.
I mean, I'm not quite sure why Lord Justice Longmore thought it was a difficult point. I mean, why it should be difficult for the distributor to continue to use best endeavours during the notice period to fulfil his contractual obligations.
Well,
Lord Justice Longmore thought it was difficult.
Well, I would respectfully agree. And
I'm not sure why it's difficult.
I would certainly agree with that, and I would say a fortiori, if it's not a best endeavours obligation, it's less likely.
If it's not difficult, then it's an irrelevant factor, presumably.
The supposition is that during the notice period they're continuing to sell ABI's product, but they're travelling around the Bahamas trying to find another brewer to fill the gap in their portfolio of beers, right? And you would think that they can't start, presumably, maybe they can start that distribution agreement before the end of the reasonable notice period. Maybe they can, as they're not exclusively bound to ABI. But what ABI doesn't want to see is that after 2 months, suddenly the amount of beer that's bought from them dwindles. I don't think there's any minimum purchase requirement in this.
No, but
I don't think we have any figures as to how much beer they were buying a month. But what ABI doesn't want is to be stuck with Burns House for however many months, and they're not actually buying any beer.
I think
Lord Justice Longmore was no doubt influenced by the experience of commercial judges that when you're dealing with distributorship agreements, once the writing is on the wall, there's diminished enthusiasm in practical reality on the part of a distributor for doing his best to sell their products.
I mean, if that's all he's saying, then I agree.
Well, that may be the difficulty.
In a sense, I mean, there's obviously going to be a continuation of the pre-existing relationship during the notice period. That's obvious. And I think my understanding of what Lord Justice Longmore is getting at is if there's a best endeavours obligation vis-à-vis the party that's terminating, then that could create particular problems during the notice period. But I just don't accept that this is a particularly weighty factor. I mean, there has to be a transitioning towards some alternative arrangements, but the parties will need to continue during that period. And I don't accept that there's necessarily a best endeavours obligation in every case, and one can simply read that across.
Can I raise with you,
Yes.
before we leave Alpha Lettings, a point that struck me? The judge quoted Alpha Lettings at some length, and on page 116 in our hard copies, she underlined the end of paragraph 31. And if you look just at the last 3 lines, he said, the fact is that Neptune's business only accounted for 20% of Alpha's overall turnover. This is an indication that a lengthy notice period should not be implied. Now, in our case, she found that the one party's business only accounted for 10% of the distributor's overall turnover. But she doesn't refer to that where she's going through the factors that lead her to her conclusion as to an appropriate notice period.
I think there is, she does consider this because I think, well, she certainly deals with the evidence on this point about it being a material aspect of the business. But I mean, having made those findings, she was obviously aware of the extent to which these products formed part of the overall business. Maybe that this point doesn't feature in 142, the concluding paragraph.
I mean, that perhaps is one of the most striking aspects of the judge's judgment, the fact that this was a small percentage of the distributor's turnover, and yet there's no mention of that in her reasoning.
Well, first of all, that's obviously not a point that the Court of Appeal is criticising her for. And secondly, again, taking that point from Alpha Lettings, I do say one needs to be slightly cautious about carrying across the finding in that case as to the percentage.
Well, the point must be, I think, one of which is generally valid, that the fact that the distributors, the manufacturers of products account for only a small proportion of the distributor's turnover must be a factor that points towards a shorter rather than a longer period of notice.
Yes, but one also has to then think about the question of the brand. I think I showed you earlier references to the brand impact. So if, for example, that small percentage was, a relatively small percentage, was a particularly important brand, which this was, because these are some of the leading products, as I understand it. The evidence was that these are some of the leading beer products. And what Mr. Mulder was saying to the judge was losing these brands will damage our overall portfolio. So I'm not sure one can necessarily, I'm not, as it were, disagreeing, but that may or may not be true. And as I say, that's one of the reasons why it's so difficult for the Court of Appeal in the Bahamas and also for this court to start to unpick particular bits of evidence or particular findings that the judge made or didn't make. I mean, just dealing with what the Court of Appeal has criticised her for, which was the best efforts obligation during the notice period. And then, if I can turn to ground 4, which concerns paragraph 29. So we saw earlier the judge had made findings based on the evidence that there had been an improvement to the warehouse, so capital expenditure, and that capital expenditure had actually been incurred, she found, in recent years. I won't go back to the judgment, but that reference to recent years appears at 106D, 140 and 1424. And so she accepted, in other words, that the investment and improvement to the refrigeration, the capital expenditure, was at least in part for the benefit of ABI. I obviously accept it was for, the evidence said it was for wine and beer products, but at least in part the judge was satisfied that ABI would benefit from that capital expenditure, and that was a factor which she said militated in favour of a longer period of notice. And the Court of Appeal criticised her in 29. They say the judgment doesn't state that that improvement was not for the benefit of the appellant and its beer products, but primarily for the benefit of the respondent and its other products. Now we say, with respect, the Court of Appeal here has committed an error because there's simply no evidence, one way or another, as to which party primarily benefited. I mean, we wouldn't accept that it's a question of primary benefit in any event, because the principle is that if you've incurred capital expenditure for the benefit of your supplier, then there ought to be sufficient time to recoup that investment.
Yes, but if you have a range of products and you create or improve your refrigeration resources, and some products will be wine, some will be beer, and 10% of the total product, roughly, let us say, or probably less than 10% because wine's more expensive, will be ABI's beer, then it's not difficult to infer that ABI may benefit, but will be a minority.
Well, just if I may, just breaking that down. I mean, the judge found that there was a benefit to ABI from its capital expenditure.
And I understand why she made that finding.
And there was no evidence either way before the judge as to what particular expenditure was incurred, as to whether it was primarily for one product or another, or there was no evidence either way. And so what my learned friends are now saying to support paragraph 29 is really the point your lordship's just put, which is, well, logically one can infer that this was primarily for the benefit of BHL. And they say that because it's 10%, ABI's products were 10% of the beer and wine products. But in my respectful submission, that may or may not be right, and that one simply cannot at this stage, and nor could the Court of Appeal of Bahamas, have assessed for itself that that expenditure was primarily for the benefit. In the absence of evidence in either direction, we say it wasn't open for the Court of Appeal itself to decide that that expenditure was primarily for the benefit of other products, and to criticise the judge on that basis.
Well, the alternative is what you're envisaging that and I don't know what you're envisaging. The natural inference is that the refrigerated warehouse is there for. They have one warehouse apparently, and it's a refrigerated section. And I think the alternative view is the refrigerated section is reserved for Budweiser, which is hardly likely.
Well, not reserved for, but well, you have the submission. It's just that there was no evidence one way or another, and so what the Court of Appeal must be doing here is proceeding on the basis of some inference, and we say it's not open to an appellate court to draw that kind of inference. But in any event, we say the fact that ABI was to benefit to some degree from the capital expenditure was sufficient for the judge to regard that as a relevant factor.
Which paragraph in her judgment does she refer to this?
She refers to this in a number of places, but
I mean, as really on the analysis and conclusion.
yes, if you look at 1424, the second sentence. I mean, in fairness to the judge, as I say, yeah. And
What
so,
do you say about the first sentence? I mean, is that a significant factor?
well, that's, I would not put that in the same category as capital expenditure,
No.
because the point I made earlier is that I would respectfully submit that points such as the senior manager and the human resources would feed into formality. Because I think it's relatively clear that it's capital expenditure which is a particular issue in order to allow the distributor to recoup its investment.
Your point really is that 1424, the judge was entitled to say that ABI, among others, benefited from the improvement in the refrigerated section.
That's the long and the short.
The judge isn't saying more than that.
Exactly.
The Court of Appeal is using some knowledge of its own to suggest that beer doesn't need to be refrigerated. They may be right, they may be wrong about it. I don't know.
We move to ground
Right,
five.
saying that wine and champagne in the Bahamas will require.
Yeah, that I think is reasonable.
Can I go to ground five, which is in relation to paragraph 30 of the Court of Appeal's judgment? And they refer to what the judge said at 1425. A very important consideration is the length of time BHL was able to replace the business loss and to find a new brand to distribute and achieve profitability. It is unclear how, we've touched on this point, I think, already to some degree, but the criticism by the Court of Appeal is it's unclear how that factored into her decision. Perhaps it was an argument against the 3 years notice period being suggested by the respondent and for a shorter period. Now, we make really 2 points about this paragraph. The first is that is plainly, we say, wrong. The judge was clearly looking at the question of how long BHL would need to replace the business loss and find a new brand as a point in favour of a notice period longer than 3.5 months. When we say that with respect, is actually completely the wrong way around, that she was using that as an argument against the 3-year notice period. So we say it's actually wrong that it was unclear how it factored into her decision. But then the Court of Appeal goes on to refer, you'll see, less than 15% of the business. Indeed, in this case, the judge accepted the evidence of the respondent's general manager, and then they quote from what the general manager's report had said, and they say this is indicative that a short period of notice would be reasonable. But if one goes back to actually look at the full extract, I think one needs to go back to 106 of the first instance judgment. Yeah, 106E, which is page 124. If you see 106E is the quote from the managing director's report, and what the Court of Appeal have done is that they've quoted the sentence beginning, but we believe the separation nets more benefits, without acknowledging the preceding sentence, and that preceding sentence we say was important to the judge's conclusions. So we say the two aspects of paragraph 30 disclose a clear error. And the only point that my learned...
He was saying that, yes, it will hurt for a year, say, or a year and a half, but that after that, it will be...
Yeah, but it's actually the underlined wording, which then the judge accepts and comes back to in her concluding paragraph at 1425. So we say, with respect to the Court of Appeal, it's not a fair criticism, or it's not open to the Court of Appeal to seize upon some different wording in that managing director's report. And the only point which my learned friends make about this, they don't deal with that general manager's report point at all. They in fact advance a new argument, not dealt with or addressed by the Court of Appeal, but they make the point that the judge has gone beyond the authorities in saying that the length of time needs to replace the business loss and achieve profitability. and I've already made some submissions about that point. And so to draw the points together, we say that none of the 5 criticisms of the judge's reasoning were valid, and accordingly the Court of Appeal didn't have a sound basis for interfering with the judge's conclusion on the facts of this case, that 15 months was a reasonable notice period. She applied the correct principles, and we say it cannot be said that the conclusion was demonstrably wrong. One thinks about the 40-year relationship, the degree of formality, the fact that there was some capital expenditure recently incurred for the benefit of ABI, and the loss or as she perceived it, the impact of termination on BHL. And so for those reasons, we respectfully submit that this board should allow the appeal. Unless I can assist any further, those are my submissions.
Thank you very much. Yes, Mr. Gordon.
Good afternoon. The Court of Appeal was entitled to and correct to set aside the decision of the trial judge as regards the period of reasonable notice and to substitute its own determination as to what constitutes a reasonable period of notice. It was entitled to revisit the decision of the trial judge for a number of reasons. First, because she failed to take account of relevant factors. Second, because she took account of irrelevant factors. And thirdly, because her finding as to 15 months being a reasonable notice period fell well outside the range reasonably available to her. As regard the failure to take account of relevant factors, first of all, the judge failed to take account of the fact that the distributor, BHL, was not subject to any restriction on selling competing products to those being supplied to it under the exclusive distribution agreement by ABI. The absence of such a restriction is a relevant factor favouring a shorter period of notice, as clear from Alpha lettings and other cases. And it's particularly significant in this case when one bears in mind the following 3 points. First, that BHL, a Heineken subsidiary, was a direct competitor of ABI, or its holding company was. Secondly, that BHL promoted its brands of Heineken and Kalik as so-called premium brands, and we'll see that in the judgment shortly, of the trial judge, in contrast to the brands BHL was distributing for ABI, which were not accorded premium brand status. And thirdly, and importantly, that BHL's freedom to sell competing brands resulted in the turnover of sales by BHL of ABI's products representing less than 10% of BHL's beer and wine sales by percentage turnover, and at 15% of beer sales alone. The judge entirely failed to take into account as relevant when she came to her decision on period, the absence of the restriction on competition, and nowhere does she take account of the percentage turnover point. The Court of Appeal itself found at paragraph 27, correctly, page 89 of the hard copy bundle, that the judge did not refer to the fact that there was no prohibition against Commonwealth Brewery selling its own products in competition, and goes on to deal with the obligation to promote, which I'll come to in a moment. And as my Lord Reed noted earlier in an exchange with my learned friend, the judge herself had specifically identified and underlined the key passage on this in the Alpha Lettings case. And we just go back to look at that at page 74 within the judge's, within the Court of Appeal's judgment. Sorry, I think that's the wrong reference. Let me just get that reference. It's paragraph 93, page 115 in the judge's judgment. on the left-hand side at the bottom.
93, isn't it?
I'm sorry?
What paragraph?
It's page 115 of the judge's judgment at paragraph 93. Page 115 being the bundle number. Hard copy bundle number, I should have said.
It's 115 to 116.
Yes.
Yes.
And if we go to 116, having dealt with absence of a formal relationship, the judge says, Lord Justice Longmore says, one result of not having any formal written contract was that Alpha was entirely free to sell products of other suppliers to their customers, even if those suppliers were competitors of Neptune. No doubt not all products so supplied could be described as competitive, but the fact that Neptune's business only accounted for 20% of Alpha's overall turnover, that's an indication lengthy notice period should not be implied. And that the judge entirely failed to take into account those points, notwithstanding their obvious relevance on the facts of this case and her underlining of this as a factor. So on that ground alone, the judge's decision was flawed and would be a basis for revisiting it. Whilst the Court of Appeal didn't in paragraph 27 refer to the percentage turnover point, they did refer to the competition point as being a factor, and there's no finding from that aspect, no challenge to that finding on the part of the Court of Appeal as to that aspect of the case. So that in itself would be a failure to take account of a relevant factor, which is of itself a good reason for her decision to be revisited. The second factor that the trial judge failed to take into account was that during the period of the agreement, including any notice period, the distributor was under an implied obligation to market ABI's products. The extent of such an obligation formed part of the submissions of ABI before the trial judge, as recorded in paragraph 108 of her judgment. Perhaps I could just briefly turn to that. So you'll find that within her judgment at page 126 of the hard copy bundle. Mr. Jenkins' submission that where a party to contract may still be required to use his best efforts to promote the products, this must militate in favour of shorter rather than a longer period. In this case, the nature of the distribution agreement between the parties was such that it would have required BHL to continue and market and promote the ABI brands even after notice of termination had been given until the agreement was at an end. And whether that obligation is a best endeavours obligation or reasonable endeavours obligation, it's clear that some obligation to promote must arise, not just because of the nature of the distributorship, but also because the terms that the judge found in relation to the express terms of the distribution agreement that the judge found, as conveniently I can take you to paragraph 10 of her judgment, page 97, include provisions in relation to marketing. Monthly annual marketing plan, at C, at A, discussing marketing activities, and then the obligation to have an experienced brand manager at F. Now, whether the obligation is a reasonable endeavours or a best endeavours obligation, it nevertheless, when it comes to the notice period, puts both parties in a difficult position. In the case of the distributor, he has little interest in continuing to build up the brand during the notice period. He will not benefit from the brand after the notice period, and indeed may not benefit from doing so if he's also a competitor. So if the distributor is making efforts over a lengthy period to continue building up the brand, he's simply giving the benefit of that to either the successor to that distributor, or if there's not going to be another distributor, then simply to ABI itself. And that causes a difficult position for the distributor, all the more so where the distributor is a competitor of ABI. And in the case of the supplier, he suffers because he's locked out for that lengthy period of time, if it's 15 months, because he can't have another distributor in place. And he's going to be concerned that the relevant efforts are not being made to build up his brand in the meantime. That all militates in favour of a shorter notice period. And not only did the judge fail to make a finding on the obligation, but we say that she should have made a finding on it, whether that was going to be a best endeavours or reasonable endeavours, that there would be an obligation to promote. There was an obligation to promote, rather, which would continue during the notice period.
I don't think that's disputed from the exchanges we've had.
No.
That the distributor couldn't reallocate its staff away from ABI during the notice period.
Yes, it had the brand manager and 3 to 4 staff.
Yes.
But that doesn't mean that it's still going to be making the same efforts, or is going to be incentivised to make the same efforts to build up the brand during a notice period than it was during the period of the agreement. So those were the 2 factors identified which we say, or 3 if you split out competition and the percentage turnover, that the judge failed to take into account and should have done. She also was in error in taking account of irrelevant factors, and just to...
Sorry, what was the possibly third factor that wasn't taken into account?
Sorry, yeah, the first factor I combined, as did Alpha, the restriction on, absence of restriction on selling competing products and the level of turnover of sales.
Oh, I see.
You might call them all part of 1A and 1B, or you call them 1 and 2.
Yes.
I don't think it matters. As regards the irrelevant factors, the first that we say the judge wrongly took into account was the high degree of formality of the distribution agreement. That's a reference to paragraph 130 of her judgment, which she relied upon as favouring a longer period. The Court of Appeal, as we've seen, found the judge was wrong to characterise the agreement as formal because it was not made in writing or even reduced to writing, and they made reference to an informal agreement in paragraph 9. That's the subject of ground 1.
What does it matter whether it's in writing or not?
Because the extent to which the parties seek to formalise their relationship is an indicator as to whether or not the notice period should be a shorter or longer one.
Why is that?
Because where the parties seek to formalise their relationship, they are seeking to recognise that they have a more long-standing relationship. And that would sound in a lengthier notice period. There's no sort of... there is some indication on that in the authorities, which I'll come to.
Supposing there were a written agreement here which contained the terms that we've seen in the judgment, and also said that the agreement was terminable by either party on reasonable notice. How would that have, would that indicate a longer period of notice than
yes, because it would indicate
oral agreement?
Sorry. Yes, it would indicate a longer period of notice because it's showing that the parties are seeking to give their relationship more formality, and with that formality is an expectation of a longer notice period.
But we don't know what the industry practices? That's one of the points that was made, that there was no evidence about industry practice. I mean, would it affect your argument if actually in the Bahamas there were loads of these agreements and none of them was reduced to writing?
Well,
all of them were reduced to writing except this one. It's difficult to know what significance to give to this.
Well,
I don't know what
industry practice obviously can be relevant to the assessment of the reasonable period of notice. In this case, there is no industry practice which is relied upon by the judge in her decision as to the length of notice. But it could come into play. As to whether industry practice regarding whether you have oral agreements or written agreements might come into play, I might need to give that some thought. I don't have an immediate answer to that. I'm going to come back to a fair bit more detail on the informality point when I come to deal with the court's assessment of the Court of Appeal's assessment of the reasonable period, and I'll take you to some case law on that. The second factor which the judge placed weight as favouring a longer notice period was the capital expenditure incurred by a distributor, by the distributor BHL at an unidentified point in time. She also, as we've just seen, referred to and seemed to have relied on the expense in relation to the brand manager and the staff. As we'll see when we come to look at Alpha Lettings, that doesn't fall into the category of expenditure which you factor in to a decision as to a reasonable period of notice, because it's ongoing, recurring expenditure, ordinary expenditure in the course of your distributorship, for which you gain benefits on an annual basis. As regards the question of the impact of the capital expenditure incurred by the distributor,
is that the refrigerated warehouse?
That's the refrigerated warehouse, or the improvements to the refrigerated warehouse. What one has to do, and I'll take you back to Alpha Lettings on this, is understand why this becomes a factor. It becomes a factor because where the distributor incurs capital expenditure, which it's going to take some time under the distributorship agreement for him to reap the benefit of, that is a factor which would suggest that if the relationship has not run for a long time since that expenditure was incurred, that notice period should be longer. That doesn't operate in our case because there is no suggestion, let alone finding, that this was expenditure directed at the need to refrigerate BHL's beers. This was just the improved refrigeration of their warehouse, a warehouse that stocked BHL's beers and its wine products. And the Court of Appeal were quite right to say that the judge was wrong to take that as one of her 5 factors into account in circumstances where that percentage of sales of ABI products was just 10% of the overall. And it's a matter of common sense that in circumstances where you're improving a fridge for all your products, that it's not primarily for the purposes of ABI's products, even allowing for the perhaps difference in price between beers and wines when you come to work out the 10%. So that was a second factor, in addition to the formality, which was an irrelevant factor which the judge took into account. And then the third factor, and I should say, in conjunction with that point, that as Alpha Lettings indicated, with regard to the length of the length of the relationship and its relevance to the notice period, there would be a move towards a longer notice period where, in fact, the relationship has been for a relatively short period of time because in circumstances where you've incurred capital expenditure, rather than a longer period of time. So actually, the length of the relationship, to the extent it's a factor at all, only really arises in conjunction with capital expenditure. And nevertheless, the judge in this case decided that the fact that this had been a profitable relationship for 40 years meant that you should have a longer notice period, and there is no support for that. So the final factor, which we say the judge wrongly took into account, was the length of time that the distributor needed to replace lost business, secure a new supplier, and achieve profitability. And just to pick up again relevant paragraphs in her judgment on this. So if I could first of all take you to her judgment at paragraph 128. Sorry, this is page 132 of the hard copy. 139 of the electronic. So 128 is her reference to the common purpose, and I'll obviously be taking you back to Australian blue metal in due course. And there she decides that due to the substantial nature of the distribution agreement, it's reasonable to infer parties intended, and then in the event of termination, each side afforded sufficient time and compensation to make alternative arrangements without damage to the other party's business. That's a confusing statement because it's not entirely clear in the situation where, let us say, ABI gives notice to BHL, whose time and compensation and whose damage is being referred to. On one reading, it's saying that BHL would be afforded sufficient time and compensation to make alternative arrangements, but without damage to ABI's business.
I think it's a limitation. I think that
yes,
is what she
it's
means.
not entirely clear.
I think it's a limitation. You might say that BHL needs N months, but having regard to the damage to ABI, that's reduced.
Yes.
I think that's how I read it. Yes.
But then let's see in a moment how that sort of feeds through.
Right. Okay.
So she's then got at 131 a fifth and important principle that this is the next page. A fifth and important principle that the court ought to consider is how quickly BHL would be able to replace the business lost. No doubt. And this in my respectful submission, one can see is the sort of pivotal factor that she takes into account when she gets to her 15 months. No doubt BHL would need to take time to find another supplier. So it's not just a question of finding another supplier or even making efforts to find another supplier, which will be a potentially shorter period, but it's replacing the business loss that she's focusing on, which goes well beyond anything that you would see in either Australian Blue or in Alpha Lettings or any of the other cases. And then how that then seems to feed through at 142, that's para 142 at page 136. We've got the echoing of paragraph 128 in 142.3. And again, it's curious, just I should have pointed out a moment ago, what she means by affording them sufficient compensation. Quite sure how that term works in the context of notice. And then really subparagraph 5, because of that 142, a very important consideration is the length of time they were able to replace the business loss and find a new brand. And it's quite apparent from the passage that's been highlighted by the learned judge that she is focusing on the evidence that was before her as to how long it took BHL to recover financially from the loss of the distributorship, or put another way, for how long BHL was suffering damage as a result of the termination of the distributorship. I mean, as to that, there is no, in my respectful submission, there is no relevant factor to apply in terms of how long do you need to avoid your business loss. In other words, how long a notice period do you need to ensure that you don't suffer loss as a result of the termination of the distributorship, so that you are kept whole as a distributor. There is no justification for that as a factor going into the period of reasonable notice. That's the first point. The second point, which I do observe, is this, that as my learned friend said, and I accept, for the purposes of the reasonable period of notice, you're looking at the circumstances as at the date that you give the notice of termination. I mean, what strikes me, sort of hearing my friend and then looking at this, has struck me as surprising in this context, is the judge, and this isn't in my written case, but I nevertheless think it's pertinent, I should raise it in front of you. The judge appears to have relied on the evidence of what happened since. In fact, you were taken by my friend to the passages in Mr. Townend's evidence, which deals with the losses suffered, and then to this production of a report, which is looking at the impact on the bottom line, both at the end of 2015, so this was in the context of the 2015 report, bear in mind the notice was given in August of 15, and its continuing impact into 2016.
Well, it could be relevant to the reasonable expectation.
Well, might be a different matter, but it hasn't been looked at through that lens.
Well, are you saying that something happened in the market that was unforeseen in that time, which increased the loss that they...
No, what I'm saying is that one would need to look at the circumstances as at the date of the notice and what would be reasonable expectation at that date. That
so you look at what in fact happened and then see whether that tells you something about the reasonable expectation, unless you can show that what in fact happened was influenced by something unforeseeable.
So that's the way that I would suggest that would be approached, is one would say, well, a good indicator of what the reasonable expectation was that you'd look at what happened and say, well, there wasn't any significant unforeseen circumstances in the interim period. But all I'm making, the point I'm just making it is, and it's not, as I say, it's not in my written case, is that it's notable that the judge hasn't taken that approach. The approach she's taken is to look at the position as actually happened. So we say that was the judge's approach on this was an error on her part. This wasn't a relevant factor. She was importing to the requirements for the period of notice a purpose which is not supported by the authorities.
Yes, you referred us to 1425 and the highlighted quote that there'll be a hit of revenue in the end of 2015 and 2016.
Yes.
And what you're saying is her choice of 15 months seems to be related to that.
Yes, correct.
Would that be supported also by 1426, where she talks about the unchallenged evidence of
Yes.
Mr. Townend? And if you go back to her findings at 86, the loss of revenue was effectively felt in the first year of the termination
Yes.
of the distribution agreement.
That's quite right.
So
It all ties together.
it seems to be that she was choosing the period of notice to reflect what was a reasonable assessment of the period of loss of profit.
Yes,
And you say that's illegitimate.
correct.
Because you say they have to be prepared to suffer some loss of
Of
profit.
course, yes.
When you balance that against the disadvantages to ABI of a long notice period.
There's a big difference, and I will come back to this, trying just to sort of give you my headline points at the moment, rather than develop them too much, because I'll deal with that after the short adjournment. But there's a big difference between having a period of notice which allows you to wind down your operations, maybe start to find someone, if you're looking for a replacement, and having a period of notice which essentially is designed to make you whole as a distributor, insulated from loss as a result of termination. In a distribution relationship, the parties know that there are risks in terms of suffering loss if relationship comes to an end, either way.
It's a cushion rather than 100% insulation.
Yeah, it's a cushion for an orderly wind down, and to the extent that you need to start efforts to find someone else. So those are the relevant, irrelevant factors, but one must not forget in my submission, it's important to remember that the Court of Appeal also found that the relevant factors all pointed to a range of a period of reasonable notice for 3 to 6 months, and that the trial judge's determination of 15 months was well outside the range of reasonable notice. And one can see that in the Court of Appeal's judgment, paragraph 31 at page 90. So they refer in the second sentence to nothing in the judgment to indicate why 3.5 months was outside the range of reasonableness. They refer to the short period of time in Alpha Lettings, Nagel, and we call it the ZL case. And then 15 months is a long period and well outside the range of reasonable notice. And then there's a comparison made with the 3 cases cited, and a reference to 3 to 6 months being a reasonable period. And then the factors which influenced the Court of Appeal in reaching that decision. Now, we say that the Court of Appeal was right in saying that the judge's assessment of 15 months was well outside the range reasonably available to her, and that itself is a ground for setting aside the decision of the judge. And it's, in my respectful submission, important to appreciate that other decisions on their own facts concerning the period of notice do have some potential relevance to a judge who is trying to calibrate the appropriate range or period of notice. My friend, on a number of occasions, seek to suggest that that isn't the right course to take, it's not an appropriate course to take. But in fact, it's the very course which was taken in the Alpha Lettings case. And If I could just take you to that in the judgment of Lord Justice Longmore. In the bundle, the electronic number is 1035, and it's paragraph 36. And at paragraphs 36 and 37, that reference to the periods in other cases and the facts of those other cases and the extent to which they differed from Alpha was clearly at the heart of the eventual decision that we get at paragraph 38 as to the period. So in 36, there's a reference to the cases of Martin Baker and Decro Wall. So those were the two English cases, noting that in the first one, the main issue was whether the agreement, which was in writing, so certainly reference made to that, and provided that the distributor could not sell products which might compete, so a non-competition restriction. So it's then said it's not surprising that the judge decided it was terminable on reasonable notice in a period of 12 months. So that's given as distinguishing factors. And then in the Decro Wall case, which was a case of an oral distribution agreement, the Court of Appeal held that 12 months was appropriate, but then three major distinctions between the case and the present. First, as in Martin Baker, there was an express provision that the distributor was not to sell any goods competing with those of the supplier. Secondly, 83% turnover, unlike 20% turnover. And thirdly, there was a substantial investment in launching and promoting a new product, and the agreement was terminated only 3 years after it began, before any real award for the initial expenditure could be reaped. So in that case, there'd been ample opportunity for the reward of the initial investment to be earned. So, so the judges, Lord Justice Longmore, was there identifying three distinguishing factors which, on the facts of the Alpha case, in distinction to those cases, and in particular Decro Wall, would lead to a shorter notice period. And just focusing on those factors, they all exist, we submit, in our case. So there's no express obligation to prohibition on competition. Secondly, the turnover, in fact, was even lower in our case than in Alpha Lettings. And thirdly, there was no relevant substantial investment in the period prior to termination of the agreement. So those factors, in my submission, apply equally in our case. And just before I leave the comparison point, in paragraph 37, the judge says, I've also derived assistance from, and this is a decision of the New South Wales Court of Appeal, Crawford Fittings, which, although not cited to us, rehearses the argument addressed to us. And then he refers there to the fact that the supplier terminated an agreement of valves with 6 months' notice. This was held to be justified by the majority of the court in a case where the distributor had agreed not to deal in any products at all other than those of the supplier. So that was a considerably more restrictive agreement than the agreement in the present case, and thus merited a longer rather than a shorter notice period. And I'll be coming to that case a bit later, particularly in the context of the purpose of a termination notice. And then those factors are all then taken into account at 38, and he says, accepting Mr. Jones's submission, we should not interfere with the judge's decision that 12 months was the appropriate notice period unless it was outside the range of notice periods reasonably open to him. I conclude 12 months was indeed outside the range of reasonable notice periods. And when one comes to look at that in the context of our case, one might say, and indeed we do say, that our case is perhaps even stronger than alpha, because we've got a lower percentage, and indeed the distributor and its holding company were actual competitors of my clients. But certainly it's no, in terms of shortness of notice period, it's no worse than the Alpha Lettings case. And yet we see the judge has arrived at a figure which is 15 months. And one can see just on that limited consideration of the relevant factors that this is a period which is just completely out of kilter with the Alpha Lettings case and the analysis in that case. And it would require something pretty extraordinary to justify leaping from a period of 3 to 6 months to a really very lengthy notice period of 15 months. And there just isn't that justification there in the judgment. And so we say that for that reason alone, the judge's decision was wrong. It was plainly wrong, and plainly in the sense that it's a decision that no reasonable judge could have reached on the notice period, and therefore the Court of Appeal were right to set aside her decision on that ground alone and substitute their own decision. So just with 2 minutes I have left, can I just indicate that what I'm planning to address in the remainder of my time, first of all, I'm going to address you on relevant legal principles in relation to reasonable notice period, and I'll have the benefit of the short adjournment to shorten my notes so I don't travail exactly the same matters that Mr. Singler has already taken you to. Secondly, I want to address you on why, in a bit more detail, applying the factors, the Court of Appeal was right to say that the judge's determination fell outside the range reasonably available to her, and in doing so I will be picking up a number of the grounds of appeal. And then thirdly, I will, to the extent not already covered, pick up the remainder of the grounds of appeal. I hope that will be a...
Okay, so on the principles from the authorities, the appellants deal with it in some detail at paragraph 17. Do you disagree with any of that? Their summary of the...
No, it's not. There are differences between what they've said and what we've said in our summary, which starts...
Are the differences of substance?
They are differences of substance,
Okay.
yes. And I'm going to take you to those, and I will cross-refer so you can see what the differences are.
Very well. If that's a convenient moment, we'll adjourn and resume at 2 o'clock.
Thank you very much.